Hello, everyone, and welcome to another Superstonk Live AMA. Today, we are welcoming a special guest host. AMA veteran Lucy Komisar is going to be hosting fellow AMA veteran Wes Christian. So, with that, I'm going to hand the floor over to our special guest host, Lucy Komisar. Welcome, Lucy and Wes.
Thank you.
Thank you very much. I'm honored to be here yet again.
So today, I am interviewing a Houston lawyer, Wes Christian, the major U.S. legal expert on naked short selling. And I've known him for a number of years, and I know wherever I speak. Now, Wes, over the last 2 decades, you have been the lawyer on more naked short selling cases than any other attorney. How did you start representing victims of naked shorting?
Well, ironically, as some people say, God had a plan. The plan occurred with John O'Quinn and I meeting somebody that was a friend of his at church, who said, listen, somebody is selling stock in our company that can't exist. We said, why? They said, well, because a group of us own the vast majority of the stock, and it's selling more shares per day than are issued and outstanding. When we heard that, we couldn't even get our head around it, but we went from there basically to investigate really what was this all about. So that's where it started in 2000, almost 2001.
Well, what was going on? What was it all about? What tactics were they using?
Well, back then, it's a great question, Lucy. Back then, what they did is they really naked short sold what I would call small cap companies, bulletin board companies. Not NASDAQ companies, not NYSE, Amex companies, bulletin board companies. And back then, those companies always needed capital. So they would enter into, the bad guys would enter into a convertible debenture. That is basically a legal note, a promise to pay money. And in exchange for that, the note would say, we, the person who's owed the money, can take shares or we can take cash for payment. Well, the bad guys would always take shares. And so what would happen is the public company would sign the note because they needed the money, because the people said, oh, we love your company. We want to invest. We really think you've got great technology. We'll loan you this money. In fact, we'll even let you repay us in shares. Boy, the company thought that's a winning proposition because, my God, I don't have to part with cash. I'm going to get cash in the door. It's great. But in reality, what that was a predator who was coming in, getting inside information and loaning you money. And at the time, let's say this company's stock, which was Internet Law Library, was, I'm making it up, but it's close $8 a share. And at the time, the amount of shares that would have to be given to the person who the note was made payable to would have been, let's say, 1 million shares. And at that time, the stock started going down and down and down, and the volume of the sales went up and up and up. Of course, as we know, Lucy, anytime sales exceed demand or supply exceeds demand, the price is going to go down. So what was happening is the mission of the bad guys was to loan you $2.5 million and be entitled, at least at that time, to 1 million shares. So by the time, that they got through with you, you would have to give them 20 million shares.
Now, there's a name for this, isn't there?
There is. It's called death spiral financing. Death spiral financing.
What happened to the company?
The company went out of business. Ultimately, the case that was in federal court in New York, in the Southern District of New York, with Judge Carter, was dismissed ultimately after we got some discovery. And because of that, basically, our first case filed was dismissed by the court.
Now, the next one, another one you did, also death spiral financing, was the EagleTech case, and you filed a suit in Fort Lauderdale. Tell us about the EagleTech story.
Yeah, the EagleTech story was another learning experience. So the EagleTech story was really about basically a company who started what I call follow me software. What that meant is when you called in on the phone, if you weren't there, that phone would be transmitted to another place, to another place, to another place until it found your cell phone anywhere in the world, called follow me software. So Eagle Tech likewise went out to get a convertible debenture. They invested with the company. That company actually was had two components to it. One, it had Solomon Smith Barney to it and several of its partners in a company called Trinity. And it had an organized crime family headed up by a bunch of mobsters, literally. And one of those mobsters was a real character named John Cerubo. And what we learned there, and this is very important for all the listeners to understand, is organized crime in every fashion, in every faction, in every aspect of this is involved in many of these cases across the board.
So tell me more about the connection to Solomon Smith Barney. We would expect the mobsters to do some of this bad stuff, but what about Solomon Smith Barney?
Well, Solomon Smith Barney ultimately did settle the case. I can't disclose for how much. We were able to get a settlement, but what you have to understand is they were in this up to their eyeballs. Much like you, I consider you probably the foremost expert, in money laundering, maybe in the whole world, but certainly in the United States. And I think you know more than anybody, but these listeners that are listening to us today need to know that organized crime launders a lot of this money through the stock market and through prime brokers and through banks. In fact, I was keeping track in the last 2 weeks of how much money had been laundered through banks and how many banks were fined. I stopped counting at 10, in the last 2 weeks across the world. Some small numbers, some large numbers. The same thing happens in the stock market. So what we learned with Solomon Smith Barney is they had teamed up with basically the organized crime family in New York. And John Cerubo ultimately gave a deposition in the case that I can't really disclose all the facts about, but basically it corroborated, let me say, our version of the facts, which was that Wall Street teamed up with organized crime. And in doing so, one of the best examples I can give you is they would pay brokers cash out of a debit card from a bank in the Bahamas. And we know that because we went and took depositions in the Bahamas of people who decided to cross the Jordan, shall we say, and become honest citizens and say, hey, we shouldn't be doing this and we feel bad. So here's what we're going to do. We're going to confess. And ultimately, that, of course, led to a criminal investigation, which was opened in connection with Eagle Tech. But ultimately, a pattern that we've seen for 20 years, the main people that got prosecuted criminally in that were the organized crime families, not Solomon Smith Barney. So Solomon Smith Barney ends up settling for an undisclosed sum, I can't say. And ultimately, the organized crime family makes their money, which I think they made $4, $6, or $8 million or something like $10 million on a $2 million debenture. Similar to the Internet Law Library case, Lucy, that stock started out at $8, $10 a share, something like that, and ended up at pennies by the time they were through with it. Because again, ultimately, if I can manufacture shares electronically that I don't have to deliver and supply exceeds demand every single day, that price is going to go down to meet the demand. And once the demand, is able to keep up, then they put more shares out in the marketplace, and it goes down again. And the game, the coup de grace, shall we say, is to take it to zero.
Now, another company on the order of Solomon Smith Barney, that is a fancy company, a broker-dealer, Knight Securities, they facilitated, according to your lawsuit, coordinated and synchronized short sales, driving it down. And what happened to them?
Knight Securities ultimately resolves the dispute with us also, but they get out of the mousetrap, okay? So again, it's a theme that was in Internet Law Library. It's a theme that's in Eagle Tech. The simple version is Knight Securities and the big brokerage firms end up, paying money. I call it a cost of doing business for how much they got in ill-gotten gains. Who knows? But ultimately, the Knight Securities, who we see in many cases, frankly, back then, paid a sum that in my mind wasn't commensurate with the wrongdoing. And again, the criminal indictments and everything else did not happen against Knight Securities.
And so the SEC and the Justice Department gave Solomon Smith Barney a pass. Now, you told me that you had contacted the SEC about that and got no response. Could you tell more about that?
I will, and of course, there's more to that story with the client too, Rod Young. So I tried to bring in the SEC, and at that time, if you'll remember, because I think we were friends back then, I don't know, but I know you've learned it since then. We were actually working with the Justice Department on Operation Bermuda Short. In fact, to tell a comical story, although it shows the reality of this, in the very depositions we were taking in the Bahamas, I had taken Don Clark, who was a person in charge of our security at the time, our security being Mr. O'Quinn's security and mine. Why? Because we were literally getting death threats back then. And basically got Don, who was the ex-head of the FBI in the Southern District of Texas, an African-American FBI agent, retired. Don handled the Achille Laurel investigation. He handled the World Trade Center bombing investigation as the senior investigator in New York, is what I was told. But Don accompanied us to the Bahamas because, needless to say, after getting some death threats in New York, shortly before that, Mr. O'Quinn and I decided we're taking Don and some other security with us. So we took the depositions at the hotel. But when we walked out of the hotel, Don's phone rang and he was having this conversation. His conversation was, oh, yeah, Bill, that'll be no problem. And I said, Don, who was that? He said, well, that's the FBI, a friend of mine at the FBI. I said, well, why is he calling you? He says, because they have the hotel staked out. I said, oh my God. I said, I'm glad we didn't do anything wrong. He said, yeah, and they want copies of the deposition and they want everything in the box that we left with. And we actually left with boxes in that case, Lucy, where the boxes were filled with names of brokers who, based on how much they manipulated the price through Knight and Solomon and other places, they would get cash on a debit card tied to the bank in the Bahamas, and they would send runners around in New York to get the cash out of ATM machines every day and bring it to them, or not every day, every week, and bring it to them in a brown paper bag. So that's how primitive it was back then.
Did that lead to any law enforcement, any actions?
It did ultimately lead to some actions. There were various connections. That had one component of that had a connection to Operation Bermuda Short, which ultimately helped land a gentleman named Mark Valentine and others. It also had a connection to the criminal investigation that they were already undertaking in connection with, I think it was Amro. I'm trying to think of the name.
That's the next story.
I'm sorry, that's Sedona. That's Sedona.
Yeah, that's the next. Let me ask you the final thing. To me, it was the final indignity that Eagle Tech was. It was just knocked to the floor. The SEC filed suit against the victim, Eagle Tech, to deregister its shares because it couldn't afford several $100,000 to file audited financial reports, because the delisting is a bankruptcy. The investors are wiped out. The naked shorters never have to cover. And the SEC finished what the mob and Solomon Smith Barney started.
I'll give you the client's version of that, which I think is reasonable. So you're exactly right. Delisting ultimately kills the company. It basically makes it a private company. At that time, Eagle Tech stock was trading at sub pennies, is my recollection. So we get the delisting notice. Rod Young can't afford really to hire any lawyers to go contest it. So what does my brave friend Rod Young do? He says, I'm going to go demand a hearing. Well, actually, he asked me, can you research for me? Can I get a hearing to contest the delisting? So we did the research for him free and said, yes, Rod, you can. Here's the procedures you need to follow. Here's the rules. Here's how to file the motion, et cetera. And so he did it. Rod Young, to his credit, shows up at the Securities and Exchange Commission with the then sitting commissioners and contests the delisting and waylays them with all the facts. They do not speak a word, not a word. And ultimately, there's a transcript actually of that hearing that you could get if you wanted to get it.
Mm-hmm.
That's no longer under investigation. You could get it under a Freedom of Information Act request, I think. And basically, what it demonstrated is Rod laid out all the wrongdoing, all the pitfalls of the SEC and not stopping this. So Rod made it clear to their face, you are complicit in this. You are aiding and abetting this. You are a co-conspirator in this by omission. Okay, because he asked me, can you do something by commission and omission? I said, yes, that's a legal principle.
Mm-hmm.
You can be responsible for omitting to do something, or you can be responsible for doing something. And so he let him have it. And truly, in his mind, it was the biggest tragedy of justice. And frankly, I can't disagree with him. I can't disagree. You've got organized crime. You got prime brokers. You got tons of evidence. And who paid the price? A couple bad guys that were mobsters. I mean, one of them, collected money from people by putting a blowtorch in his deposition, put a blowtorch on them, put holes in their body to collect the money. Okay, well, that's really awesome. So, but what happened to the other people? Wall Street, the answer is nothing other than pay some money.
Now, there was another death spiral case just at about the same time, and it's the Sedona story that begins in 2000, and your case gets filed a couple of years later because meanwhile other things are happening. So tell us the Sedona story and the death spiral financing. Who were the big guys that were involved, and who did the SEC and the Justice Department decide to go after?
Sure. Sedona was a software company, basically, and was run by some really smart people. And at that time, they were getting courted by a firm called Ladenburg Thalmann. Ladenburg Thalmann, at the time, one of its principal shareholders was Carl Icahn. So Carl Icahn, as you know, is a well-known name, Lucy. Somebody that you would consider prominent, somebody that you would consider incredibly legitimate and fair and reasonable and follows all laws. Unfortunately, Ladenburg Thalmann's trading desk and investment desk was run by a guy named Michael Vasinkovich. And I believe the origin, I'm not certain of this, but I believe the origin of Mr. Vasinkovich was Russia. So ultimately, Sedona Corporation enters into another convertible debenture, or you're calling it death spiral financing, which incidentally, just to segue for a minute, basically, death spiral financing means you're going to spiral into debt until you die. And spiral means spiral down, not spiral up. Because again, the mission is to take your stock to zero, because if they can kill your company and your technology, they never have to cover anything. It's no different. I call it burying the dead bodies. You're burying the dead stock certificates in a death spiral financing, because in fact, the stock certificates don't really exist. You're actually burying somebody's account statements that say they have stock, but really they don't.
But just to intervene a little bit, just to explain what it means, if you make a loan, and I think in this case for Sedona, it was $2.5 million, and you have to pay back, maybe it was $3 million in shares, but it's shares and you think everything's going up, you're getting this loan, it's going to grow the business. But if they knock the share price down with naked short selling, 3 million worth of shares may be the whole company, because the shares now are worth what, a 10th, a 20th? So the number is important. $3 million worth of shares gives them the whole company. And that's the deal. And that's how it works.
That is exactly how it works. It is a way, when you think about it, to take the company over. Over the years, we've done 20 of these cases. And so we're getting ready to file a couple more. We just filed one in the Southern District, as you know, the Harrington case. Basically, it is a way to either destroy the company and bury the dead bodies, the stock certificates that don't exist, or it's a way to steal the technology. I've seen it both ways. If they really like your technology, they will go in and right before the company totally dies, they'll put it in bankruptcy, buy the assets out of bankruptcy for what they're owed, and go from there. So you're right. Their mission is to start out with 3 million shares, and ultimately you owe 100 million shares in order to pay your $2.5 million worth of debt.
Now, tell us about how this worked and about these Badian brothers from Vienna.
Yes. Yes, we had the privilege, incidentally, of deposing Thomas Badian in Austria. I'll explain that in a minute. That was quite interesting. Anyway, so Thomas and Andreas Badian were brothers. I believe, in all my heart, that they were part of the Russian mob. Basically, they were involved with Michael Vasinkovich and ultimately involved with Refco. And what ends up happening is ultimately Sedona's death spiral becomes reality. The stock's going down and down and down, and they hooked up with another company that you correctly said a minute ago applied to Sedona called Amro. And ultimately, the Justice Department, we worked with the Justice Department on that matter. Thomas Badian and Andreas Badian got indicted in the Southern District of New York. I spent many hours working with assistant U.S. attorneys in that case and one SEC agent in that case. For reasons unbeknownst to me, after we worked on this relentlessly and had tremendous facts, Andreas Badian's indictment is dismissed. And then I get a call one day and says, well, Thomas has fled the country. I said, he's a criminal in flight, for God's sakes, arrest him. Okay. They said, well, he's on his way to Austria. I said, well, fine, extradite him. They said, oh, no, there is no extradition treaty from Austria, which, of course, was their citizenship. But what this case not only stood for naked short selling, it also showed, again, another criminal element to this, because ultimately Sedona, unbeknownst to many people, was the catalyst that led the Justice Department and the SEC to Refco. Refco was run by a gentleman named Bob Bennett. Bob Bennett ran Refco, which was a company that went public. It had an IPO. It raised a very large sum of money, hundreds of millions of dollars in the IPO. But within very few months, I don't remember the exact number of months, 6 months, 7 months, something like that, Refco was in bankruptcy. So as the bankruptcy lawyers and the Justice Department got involved in it, what we discovered is that some of the same people in Sedona were also involved with Refco. And where did Refco get its money from? It got its money from a hedge fund in New Jersey. The two principal members of that LLC, or whatever the entity was from Moscow. And they did banking at a bank called BAWAG, B-A-W-A-G Bank in Austria. Now that bank, I'm told,
it's a criminal bank.
It's a criminal bank, so it's known. So you would know more about that than I do, but I was told from a reliable source that is a mob bank. It is a bank controlled by the unions and the mob. And basically, ultimately, Bob Bennett goes to prison. Everybody that put up their money, basically, more or less, because of the bankruptcy of Refco, went down. That whole company was liquidated. But interestingly, Lucy, which is another probably unknown fact to the listeners, if you went and looked at the bankruptcy schedules, that is, what are the assets and liabilities of Refco at the time of their filing, which is something that has to be dealt with legally, the number, my recollection was north of $900 million, something like that, fails to deliver on the books of Refco. Now, incidentally, I'm told by the accountants that that's marked to market. What that means is that the fails to deliver were worth a lot more, years before that or whenever Refco started. But at the time of their bankruptcy, they had gone down and they were still $900 million. Whatever happened to those shares, I would imagine they never got delivered because Refco was in bankruptcy.
There's another interesting wrinkle to this about corrupt money using offshore. And tell us about Mr. Botliner from Liechtenstein and the offshore companies and who he was, because he had a reputation as a criminal. And this is one way of moving criminal money into the U.S. economy.
No questions. So so Batliner, no question, was a known criminal. I'm getting this from Justice Department sources. We also work with them in connection with the Sedona case. And ultimately, he lived in Liechtenstein or Liechtenstein. I don't know how you pronounce it.
Stein.
Is it Stein? Okay, Liechtenstein.
Yeah.
Okay, I'm not. I need to bone up on my German, I guess. Anyway, so ultimately, what they were doing is laundering money through lawyers' trust accounts, through convertible debentures, through other means. And when you think about it, it is a perfect way to launder money. Money comes in offshore. It comes in offshore into a lawyer's trust account. That lawyer represents the client who makes the loan to Sedona or whoever else. And ultimately, that money becomes clean by virtue of you getting shares. Those shares are then put in a brokerage account. They're sold and liquidated. And next thing you know, you've got a perfect laundering scheme. In fact, in a different case that we took depositions in, the perpetrator had set up 125 offshore companies, 125 through one law firm. And in doing so, Lucy, they prepaid the law firm to liquidate the companies within 6 months after they lent the money, because their intention was to kill the company in 6 months, liquidate their position, and liquidate the company so they could take the records and destroy them, whether it was in Cayman, Liechtenstein, wherever. But clearly that case, Sedona case, had organized crime in it for sure, via Batliner, via Thomas Badian, Andreas Badian, via Michael Vasinkovich, and via ultimately Baldwag Bank by virtue of what happened at Refco.
Now, in one of the filings that you wrote up, that you presented, I picked up the line that the SEC showed that 82 companies reporting investments by Amro, which was the company involved, the shell company involved in this, 81 of them lost almost 40% of market value in the first year. Now, if the SEC knows that, besides maybe going after one of the Austrian brothers, did they do anything to deal with this whole death spiral financing?
No. In fact, to the contrary, what I think happened, Lucy, from my perspective, is I think the companies that entered into death spiral financing were punished. I think the victims become the hunted, and that not vice versa. But it's really no different when you think about it with what happened in Reg Show. In Reg Show, which went into place January 1 of 2005, what you're going to see is that the name of the companies whose shares are being sold but not delivered. So the company that gets raped gets their name posted. The rapist who sold the shares and never delivered them of the company that got raped is not, their name never appears. Well, the same situation happened with those death spiral financing companies. The companies were the ones who were the hunted, frankly, by the SEC, not vice versa.
Now, in May of 2003, you filed a civil action for Sedona against Ladenburg Thalmann, Vasinkovich, Badian, Rhino, and others. What happened to that?
What happened ultimately with that is we had several mediations in that case, and ultimately they settled. Some portions of it were dismissed. So ultimately, from my perspective, it wasn't that successful of a case. One, it was in a tough place at the time, the Southern District of New York, although, frankly, the judges there have become much better at paying attention to this, in my opinion, and become a lot more objective. But at the time, frankly, this concept of naked short selling was, frankly, a hard pitch to a judge. And in their defense, I would have to say, I kind of get it. I remember the first time I was in front of one of the judges, they said, or one of my colleagues was, I take that back, another colleague was in front of him and said, basically, you're from Mars or something, telling me the story. You need to put on a Martian suit because basically this can't be happening, surely, because the SEC would stop this. They can't be selling assets that they don't deliver. That's stealing. Well, yes, it is stealing, Your Honor. Mm-hmm. But what ends up happening? The answer is not much. Not much.
And especially in this case, the co-conspirators, Pershing, Westminster, Frankel, which is a market maker, nothing happened to them. They got a pass from the SEC and the Justice Department. So this, it seems to me, encourages them to compete, to repeat this kind of behavior.
It does, Lucy. I've commented on this many times in the written word, and Forbes and Wall Street and all the other publications we've been in, and on shows like this, I've commented on it. The consequences for the people that are really principally responsible for this is not commensurate with the crime. Okay, it's that simple. So you and I both know, Lucy, that if we Xeroxed our car title and Xeroxed it 10 times and sold it to 10 different people, but only had one car, we'd be in jail in 2 weeks. Okay. The problem is this is done at such a high level. It involves trillions and trillions and trillions of dollars. It's done by machines now. It's done by high-speed trading platforms. It's done by overseas transactions. It's so complex that in order to really understand it, you have to spend 20 years in the ditch like we have to really understand it and be able to track it down and know how to find it.
So to finish Sedona, it now has a market cap of 1.9 million and the stock trades at 2 cents.
And that in itself is another story. My dear friend and colleague, Rob Shapiro, said it best. He said, it's not that they just stolen this money, because Rob Shapiro said, and again, for the listeners, Rob Shapiro runs a company called Sonocon. He wrote a paper, this is about 10 years ago, but he said it's even worse today in his opinion, that said 500 million to 1 billion shares per day are sold but not delivered on all exchanges. Now that goes down to something, maybe a third of that by the time you go out to T plus 30 or T plus 60. But even still, the numbers are astronomical that are being sold but not delivered. He said it's not just the cash. It is the fact of the jobs that have been destroyed, the families that have been destroyed, the technology that's been destroyed, and the lack of confidence in our marketplace that is the tragedy here. This isn't just money. This is impacting in a very negative way people's lives. It is impacting us in a negative way about advancing technology, whether it's cures for brain cancer or some different kind of word processor or whatever. Inventors no longer are safe in taking these companies public because it's easier to kill them, Lucy, than it is to build them up, because I can simply manufacture shares, sell it, and ultimately exceed demand. And I promise you I'm going to make money on my shorts. O'Quinn said it's rigging the market. You're better off, when we got interviewed by Dateline, you're better off to be dealing off the bottom of the deck, have them deal off the bottom of the deck in Las Vegas than you are to do this.
So let's go into another famous name case. And there were 2 cases of Overstock. So, and you had 2 cases here. The first, interesting, collusion between crooked stock analysts and hedge funds. And the second was creating counterfeit shares. So the first case was in 2005. And maybe you can tell about that, how involving Gradient Analytics and David Walker, Mark Cahodes.
Yes. So all of this is in the complaint. Obviously, what's in the documents I can't talk about because there's a protective order, but I can give you the summary. So let's start with some basic understandings of how you further rig the market, as if selling shares that you don't have isn't bad enough. What the perpetrators do is they start an SEC investigation on you, which typically is fake. They did that in Overstock at the same time, or actually right around the same time we filed the first case. Number 2, they go to analysts, in this case Gradient Analytics, and start printing smack about you, and I'll get into those details in a minute. Number 3, they file a class action lawsuit against you, which in fact did happen, alleging bad behavior. Number 4, they sell shares that don't exist. And then number 5, they pay bashers either in the media or on the boards, on the bulletin boards or whatever, the talking boards, to talk smack about you. So that's kind of the perfect storm, which is Patrick Byrne, my dear friend and a fellow warrior and patriot of this country, I might add, said it best when he said, I got a call one day and somebody said this was going to be happening to us and to look for these 5 things. And sure as hell, a month later, those 5 things occurred. So in that case, what happened is it was unique. We got a break because a person became kind of religious and said, hey, I can't live with myself. Let me tell you what's going on at Gradient Analytics, which was another name for the company was Camelback Research. This was a firm that purportedly was charging creme de la creme hedge fund clients large sums of money, like $25,000 a year, to get a copy of their independent, comprehensive recommendations on what to buy and what not to buy, their report, their analysis of public companies. But unbeknownst to their customers, David Rocker, along with Mark Cahotis, were in the process of editing secretly the report, in particular with regard to overstock. A large sum of money was paid to the analytics firm to allow them to do that. And incidentally, once I give you that report, please hold the report for 3 days while we take our short position and then mail it out. And the mission being to mail out the report. This is my version. We didn't prove this in the case. Mail out the report. You read the report. Oh my God! Overstock gets an F for 3 months in a row. Charlie, short that stock because it's worthless. Look at this report. Well, in fact, that is what happened. And so ultimately, we sued Rocker Partners, which was a hedge fund, I think $1 billion or $2 billion hedge fund, run by a gentleman named David Rocker. We sued David Rocker. We sued Mark Cahotis, who purported to be a chicken farmer, but no disrespect to Mr. Cahotis, but that's the farthest from the truth in my view. And we sued a couple others, I think. That case was over in across the Golden Gate Bridge in whatever county that's in. That was in state court, and ultimately it's settled. I think some of that's public, maybe 10 or 15 million of it's settled, some of it's confidential. So I can't really tell you about that. So,
yeah, I saw the figure 5 million.
How much?
5. I saw 5.
Well, maybe whatever's out there in the public is public, and the rest of it's private. But I can tell you, we were happy with the settlement. The rest of it.
Did financial reporters repeat the Gradient charges about overstock when they first came out? That were in the report.
Say that one more time. I'm sorry.
Did financial reporters report what Gradient said about overstock when their report came out?
As far as financial reporters, in my mind, wouldn't touch it. The ones I talked to. So maybe if you're talking about somebody else, I don't know.
No, I was just curious. I didn't know.
No, they didn't. They didn't really touch that. You know what? That's another phenomenon you need to understand is these prime brokers in Wall Street, is some of the biggest customers to the financial press. And so, anybody who was brave enough to write about it, and there were many back in the early 80s, mid 80s, and even
what I asked was when Gradient initially made the charges, did they write about it? And then did they write about it when Gradient and Rocker had to pay the settlement?
Yes, they did. They were kinder to our cause when they ultimately had to pay the settlement. They absolutely were not kind before then, frankly. Like basically we're out to lunch but to defend them a little, when you think about it, it's such a preposterous story. Mm-hmm. To think that somebody would go to that extreme, Lucy, that they would be that crooked. You know what I'm saying? People like to believe in goodness, and it takes a lot to destroy their dream. You know what I'm saying? So yeah.
Let's go to the next case, because this really does involve, as you said, the creme de la creme. So this was an overstock case. Your case against Morgan Stanley, Goldman Sachs, Bear Stearns, Bank of America, Bank of New York, Citigroup, Credit Suisse, Deutsche Bank, Merrill Lynch, Lehman Brothers. I could just call them the old boys club. So they control about 80% of the prime brokerage market. And so your charge, tell us about the charge of what you said they were doing to overstock.
Yeah, so the charges there, again, that was in state court in San Francisco. I started that case with a firm called Stein & Lubin. We always hire local counsel. I think at the time I was counsel in some other cases in California. In California, you can only be counsel in like 2 cases at a time or something. In any event, I never got on the pleadings in that case, but I essentially taught Stein and Lubin how to do the case. And they're very good lawyers, the 2 lawyers that did it with me. Anyway, the point is we sued the brokers because we had evidence, in our opinion, that showed that they were selling shares that they weren't delivering. And at that time, there was a Pacific exchange there that we got some information from that made us feel that way. Ultimately, in that case, which went up and down to the Supreme Court of California at least once, maybe twice, I forget how many times. In that case, ultimately, some discovery was filed, interestingly, and in that discovery, which was confidential, ultimately was put and attached to a response that one of the prime broker's lawyers by mistake filed. And when that was filed, the emails from the president of the subsidiary that told his compliance department, shut up, I don't care what the blankety blanks say, just keep selling it, I don't care. Somebody was complaining about that. Well, that was quite embarrassing to them. That case, ultimately, many of the prime brokers settled out early. Mm-hmm. Merrill Lynch ultimately held on to the end. They were the last to settle. That case had a bunch of different type of claims in it because of different things in California, different laws that you can bring different theories in. And I think the last part of that case, which settled for $20 million, was public. Mm-hmm. The other ones I can't talk about because they were subject to a protective order and a confidentiality agreement. But that did involve all the main brokers. It did have all the 5 things against Overstock, but unfortunately for them, it had a very courageous man, Patrick Byrne, who, was pegged as a Looney Tune, as I was early on in this, and has ultimately ended up being a crusader, frankly, to this day to stop this carnage. So
now, just because it's so amusing, some of the emails that were in this document, which was really redacted and was not supposed to see the light of day, in response to an inquiry by Wolverine Trading, the Goldman Sachs clearing unit's largest client, about whether there was an effort at cleaning up fails, Goldman emailed back, "We will let you fail." The president of Merrill's clearing unit said in an email about the possibility of failing market maker trades, "Why would we have to borrow them? We want to fail on them." So it was quite clear they really hung themselves. Now, one of the other things that came out in this was about conversion shares.
Yes.
The importance of the testimony by the same Mark Cohodes. Now, he was on the outs with Goldman because of some problem with a margin trade, they had cut him off, and he was a big client, so he was very angry, and he testified in the Overstock case about conversion shares, and I want you to explain what it was about. I can say he said, a firm or a market maker would synthetically create a short position by doing options trades in it, buying the stock, selling a call, buying a put, or this, that, and the other. And then they could create a borrow or off an option trade. They would borrow and lend the share they had created. That was in the evidence done. So can you explain it in a very simple way? How do you do conversion trades? Because it's what happens in all the cases now. You learned that it's in all.
It pretty much is in all the cases, and actually they call it exactly what the email said: synthetic shares. So in its simplest form, what it is imagine there's 2 members to the conspiracy. One goes out and buys a big put contract, let's say 50,000 shares in the aggregate.
Explain to people what a put contract is.
So basically a put contract is where you think the stock is going to go down. You think it's going to decrease in price. And so you are going to, let's say you think it's going to go down to $40 a share. and you'll buy 50,000 shares, but it's for a specific time period. So your put contract is betting that the stock's going to go down. The call is the opposite of that. You think it's going to go up. You then go and purchase that contract, the same contract with the same date, with the same amount of stock. And then ultimately, if you take a put with a call, now you have two ends of the pipe, and you put the pipe together, you got a piece of pipe. In this case, you've got a synthetic share. So ultimately, you can go to the option market, assuming the issuer has options, and then you're able to create that synthetic share. Now, why is it important? Why? Because you can show it to the compliance department to show, look, I have these shares. Let me short. Let me do whatever I want. But what happens is a day or two before the contract matures, because every option contract has a maturity date, that group of perpetrators says, oh, no, we're going to just tear the contract up, until their compliance department comes knocking again and says, oh, you don't have any shares to cover this. Where are the shares? Oh, we have this synthetic share that we created with Goldman and Merrill. And so therefore, ultimately, we're okay. We're in compliance. It is just another scheme of where something fake is created. The amount of fake things that are created, the amount of counterfeit things that are created in this scheme is endless, whether it's fake lending, fake options, fake sales, down the list. It's all fake, except
now,
for the
let me ask you, a lot of the emails, Cahoda's testimony, it showed that Goldman and Merrill, particularly because the emails were from their offices, others were doing criminal stuff. Did the SEC go after them? Did the Justice Department go after them? Any of them?
No, they did not. In fact, who did the SEC go after? Overstock. But guess what? The good lawyers, not us, because we don't do that kind of work. Their lawyers, I think, here in San Antonio, Bracewell Patterson was my recollection. Whoever, some good firm got that entire thing dismissed by the SEC. And equally as important, I think Patrick Byrne insisted on a no action letter. And ultimately, that no action letter was delivered, as my recollection, from the former general counsel, Mark Griffin, who's a dear friend and a great lawyer, and Jonathan Johnson, who's now president of Overstock, who's a lawyer, were instrumental in getting that no action letter, is my recollection.
Okay, and on to another case where they were using some of these same tactics, and this is the taser case, taser as in stun gun. This was filed in Georgia in 2008, and some of the same good old boys, Morgan Stanley, Goldman, Bear Stearns, JP Morgan, Merrill, all of them. And tell me about some of the tactics, because now as you're getting more into this, you're learning a lot about the various tactics that they are using.
Yes, and so let's start off with some unique things about that case. One, it involved the Smith family. In fact, sadly, we just lost Phil Smith, who was the chairman at that time, the dad. That dad had two sons. One of those sons, and Taser, ran that company. The other son, incidentally, is very heavily involved in Reddit, if not started Reddit. But anyway, that's just a side note. But in the Taser gun case, we learned that one of the ways we can make Wall Street more accountable is to sue them under RICO. What some of the listeners may not know is in 1998, an act was filed called the Private Securities Litigation Reform Act. PSLRA by acronym is how we refer to it. One of the things that act did, and I think the later chairman of the SEC, Mr. Donaldson, was responsible, my recollection is, for getting this passed, was if you commit securities fraud now, as of 1998, you can no longer be sued under federal racketeering. Federal racketeering is what they use to take down the mob. And frankly, in my view, what's going on is mob-like behavior at this level of criminality. But nonetheless, foreseeing, I say, this is Wes Christian's version, Wall Street saw that they were going to buy the National Securities Clearing Corporation, SCC, which is the stock lending arm of the DTC. And they decided, we're going to make sure we can't get sued under RICO. So guess what? That law got passed in 1998. So what O'Quinn and I did, and I give John, who's deceased as we know, credit for this concept. Why? Because he had broken the back of tobacco in Texas by using a federal RICO statute. So we talked to our good friend Bob Blakey, who I still use today, who wrote the RICO statute, who lives in Arizona, incredible lawyer. And, handled the Kennedy investigation, assassination, the reinvestigation, et cetera. Anyway, we said we need to figure out a way to sue him for RICO. And so what we did is in Georgia, which was successful for the first time, and we've done this many times since then, is we sued them under state securities laws. So we sued them under Georgia securities laws. We figured out a way to get jurisdiction in Georgia, which is quite complicated. And we figured out how to sue them for RICO because under some states, including Georgia, they have their own state RICO statute. Well, guess what? There is no state that I know of that excludes securities fraud from being a predicate act under RICO. And so we sued them under RICO, which means if your jury finds that they committed 2 acts of fraud within a 5-year period, your damages are automatically trebled. So imagine that you get a verdict for $100 million, it goes to $300 million. And then you can further get, potentially, it varies state by state, a punitive damage trial plus attorney's fees. So from there, basically, we then got into the meat of the case, and we discovered several things, which incidentally are in regulatory actions. So I'm going to speak of the regulatory actions because, again, all the documents in that case are under confidentiality order. But similar to what's in the regulatory actions, the following things occurred that were new to us. One is we learned about the amount of money that Wall Street makes off of stock lending. So you wonder why you see all the same bad guys? Because the proprietary trading monies they make, I think, is their number one moneymaker.
Yes.
I think their number 2 moneymaker, and maybe it varies year to year, is stock lending. The amount of stock that was lent in that case was multiples in excess of what was issued and outstanding in Taser. So what that told us for the first time is locates, as they call them. So a broker wants to short. He doesn't have the stock. His customers don't have the stock, which is a whole nother story. Why would you short against your customer stock that you sold them to go up? But we're not talking about that today. That's another carnage. But believe it or not, that's legal because you sign a margin agreement that gives them the right to own your stock. But getting back on point, if you don't have the stock, then you call up Merrill and say, give me a locate. And they'll say, sure. They'll say, what's the negative rebate or what's the VIG? Well, it's 20%, 30%. If it's on the hard to borrow list, don't forget brokers get a hard to borrow list published each day. They get a easy to borrow list. So on the hard to borrow, it could be as much as 50% VIG, which is crazy anyway. And what we learned in that case is that Merrill and others were giving locates on the same stock to multiple people. So ultimately, as the regulatory actions reflect, which again is what I'm basing my statement on, is they were giving multiple locates on the same share. So that's another problem with the system. Is, that same share is being lent over and over and over. And the reason is, as always, follow the money. The money being made off of stock lending is billions and billions and billions per year for these firms. That's that. Next, we learned that the stock was being traded here and ultimately bifurcated. That is, the delivery obligation went somewhere else. So imagine that Merrill or Goldman or whoever, pick a firm, sells the stock in the States, and then they send the delivery obligation to some affiliate, and there it sits, okay? So it's called a repo certificate in the regulatory action. So what you're going to see is that you're going to see that the concept that's being used, again, is to figure out a way to not deliver, figure out a way to obscure it, figure out a way to put it in a place of darkness and make it, frankly, harder to go find. The SEC, to their credit, I'll give them credit where credit's due, has at least have covered some of that. I mean, nowhere close to what needs to be uncovered and punished, but at least they've exposed it to some extent with help from us. In fact, in that case, the SEC worked with us and subpoenaed documents from us to ultimately culminate in some perjury charges against one of the prime brokers. I don't remember which in that case, and ultimately write some of the regulatory actions about the very thing I just spoke.
Mm-hmm. So, some of the numbers I saw in your own suit, in the Taser suit, which I found really astonishing, and I'm sure that this was at the SEC, comparing this was Morgan Stanley in 2007, their DTCC position, which is the stock that is listed in their name, which in the warehouse, which is the DTC, was 2.6 million shares of Taser. They claimed 11.7 million shares of Taser. That's a 9.1 million difference. They were all counterfeits. They were not real shares. And it was true for some of the other prime brokers. I saw, again, in your lawsuit, that Merrill held for clients under 2 million Taser shares. One of its clients, Knight Securities, we talked about Knight Securities before, yes, traded 219 million shares during a period of under a year. How is that at all possible?
It's not legally possible. It's possible because they're not being punished for doing it sufficiently. But absolutely, it's possible because they are doing it. The reality is that they have so many different ways to obscure it. For example, Lucy, you know this issue, but our viewers may not, our listeners may not. The way they do a lot of this is they mismark the tickets. So they'll mismark a ticket long when it's really a short, okay? And then ultimately they got to figure out then what do you do with the fail to deliver, okay? Because even if you mismark the ticket, which means you're going to circumvent reg show, so you think. And incidentally, when that ticket's mismarked, it never shows up in your short interest. So really, the actual short interest in a company is multiples of what the reported short interest is.
And the short interest is the shorts that have not been covered.
That's correct. And so ultimately, what's lying out there, I call them dead bodies, the shares that don't exist. The dead bodies are enormous. They're in various graveyards. They're moved around. It's very complex how it's done. But the bad news is through 20 years of practice and really starting about 7-8 years ago, we figured out a way with various vendors and our own proprietary technology to figure out the very differences that you talked about.
Yeah, it's from your case.
From our case.
About the 2005 vote, the Taser vote.
Yeah, so this is another byproduct of this carnage. So ultimately, the Taser vote has more shares show up to vote than exist. Okay, now mind you, that doesn't count the people that own 1,000 shares that take their proxy vote and throw it in the trash. They don't even mail it in, right?
Right, because they had about 61 million shares outstanding. How many votes were there cast? 82 million, an overvote of about 20 million. And at that date, there were 17 million Taser shorts. Nobody knows where the other 3 or 4 million counterfeits came from.
Well, and don't forget, Lucy, that doesn't count two things. It doesn't count the brokers who sold those shares on their prop desk. They didn't mail their proxy in because that would expose them. So that's how many millions of shares, I don't know. And it doesn't count the other small investors, which is a large number too, who simply just don't take the time because a lot of people don't think they can make enough impact by mailing in the proxy. You follow me?
Yeah. What was the result of the Taser case?
The Taser case was a case, let me just say, we were very happy with the settlement. I can't tell you what it was, but we were happy with it. And ultimately, my colleague in that, John Floyd, Bondurant, Mixon, and Elmore, a great firm in Atlanta, Georgia, he's kind of the successor on RICO. He's the RICO expert to succeed Bob Blakey, who is a good friend of his too. We settled that case, and ultimately, like I said, the SEC got involved in that case, to their credit, and subpoenaed documents and indicted somebody, I believe, for perjury and some other things. And ultimately, that led to other regulatory actions exposing some of the things that we found in Taser.
What was the key evidence that won it for you?
The key evidence, there were several items of key evidence. The amount of money that was made, I can't recite the number, but it's enormous, off of stock being lent that did not exist. In fact, I'm glad you brought that up, Lucy, because one of the things I learned at that same time, that was, what we settled that case in 2012, somewhere in there, or no, maybe 2009 or 10, somewhere 9 or 10, because O'Quinn died in 9. So I think we settled it in 2009 or 10. So what we learned in that case is a bunch of hedge funds found out somehow from some publication, some journalists had written about our case. And so they went knocking on their broker's door that lent them stock. And they said, I want you to prove to us you had the stock. And so they sued for breach of contract. So a legitimate hedge fund, so it finally came around the other way. Legitimate hedge fund sued the prime brokers and said, you cheater, you charged me tens of millions of dollars for loans and you didn't have the stock. I want my money back on breach of contract. I'm like, thank you, God. Finally, I've got them fighting it against themselves. Okay, so. But yeah, there were 2 or 3 suits, I don't have them memorized by name, of what I would consider reputable brokers, hedge funds, I guess, who sued their own brokers for lying to them about stock that they charged them for that didn't exist. Well, that's what turned that case around.
Yeah. The 2012 date you mentioned, that's when you filed the Razor case in Georgia, there, Salt Lake City, Utah, company that was in the geothermal construction business, and big manipulation of shares for a long time, 2003 until 2011. So talk about what went on in that case. What kind of tactics did they use?
This is a good example. I'm glad you brought that case up. And part of that case is still going in Utah today because it got some of it was in Georgia, some of it was in Utah. But we filed the case in Georgia. We did it, frankly, because we had an enormous group of Georgia investors there. We also filed it there because of John Floyd, who's a great lawyer in his firm. We also filed it there because of Chamberlain Herdlicka, who's another great firm that's there, my friend Jimmy. And basically, we filed it there because of the court systems we thought were fair and honest there. So in Razor, what it demonstrated is this. What started out as death spiral financing and bulletin board companies go up the food chain, went up the food chain to where, in this case, Merrill Lynch, as the complaint articulates, made a convertible debenture loan to Razor for like $55 million, not a small amount of money.
And they took a big commission.
And they took a huge commission. Of the 55 million, their commission was over 20 something million.
It was 23.
Yeah, 23 million. And so, but their logic behind that was they had to close it in 2008, and the market was crashing. Of course, we all know. So the company, desperate for cash, took it. But in the papers, it was represented that they would not be, and this is all in the case, that they would not be using those shares to cover prior shorts, which incidentally is illegal, as you know, Lucy. You can't do that. And so ultimately, we showed that they did do that. And so we said, look, we've got you, and, et cetera. So the Georgia part of the case settled. And that left the Utah part of the case, which is actually the bigger part of the case. That case is now up on appeal. Originally, it went up on appeal based on jurisdiction. That is, the trial judge in Utah said, Utah doesn't have jurisdiction over Merrill in that location. We said, we do, Your Honor, and I'm sorry, Merrill and Goldman. All that's left in the case is Merrill and Goldman in Utah. That went up to the Supreme Court of Utah. They agreed with us, sent it back down. The same trial judge said, well, I think I need to dismiss the case anyway. We're like, what? And so he dismissed the case, not on the merits, on some other technicality. And so that's now on appeal. But what we learned in that case, which is equally as important, is that the fake puts and calls, the fake synthetic shares are being used. Hiding the fails in offshore subsidiaries, which the SEC also has in regulatory actions, is the prevailing way to do things. There are computers that are actually being programmed, if you can imagine how complicit this makes you. There are computers that are being programmed, Lucy, to mark a short long, to mark a easy to borrow, hard to borrow, easy to borrow, and to manipulate the software to where basically you circumvent every rule that the SEC tried to set up to their credit, whether it's Reg Show or some other rule. And ultimately, as I'm sure many of the listeners and viewers know, a lot of this is done, at light speed by high-speed trading platforms, dark pool platforms, pipes, as we call them. So ultimately, we learned, as we always do in these cases, there are other ways that they're trying to stay ahead of the curve, new ways to basically hide it. But all those ways culminate in a couple different things. One, I'm not going to deliver anything. Everything I'm creating is a lie. It's fake. And incidentally, I'm going to sell you, a box of bolts that are worth nothing. You're going to pay me millions of dollars, and I hope I never see you again. So, I mean, basically, it is at its base form lying, cheating, and stealing.
In looking at the case that you filed, some of the things I came away with, shares of Razor stock that were traded by the prime brokers, but the DTCC records show little, if any, change in their net positions. Well, if they're either selling or buying to a client who has another prime broker, you have to have either less or more shares. That has to show something was changed, and they don't see it. One of the things you pointed to was in May 2009, 2.8 million shares were traded. The DTCC's record, and I believe this was for Merrill, a reduction of only 440,000. 2.8 million traded out. They show 440,000, because you can do a lot of trades, but you have to send real shares to the DTCC. You can't send your counterfeit shares there. Another point on that day. The New York Stock Exchange reported that 79% of Merrill's volume was short. So most of them have to be naked because, when they sold the shares, there were no shares moving in the DTCC. So they were not real shares. So, and here we go again. Knight. We have to look into this company called Knight.
We are.
Over 900,000 shares sold by Knight. But the DTCC position indicate there was no reduction in the inventory held by Merrill, which was providing the clearing services for Knight. So just the numbers, the numbers will show what's going on there. And I assume that some of that must have persuaded you. Now, I noticed that the Merrill also did a death spiral operation. Can you talk a little bit about that?
Yeah, because ultimately, if you'll remember my prior comment, they came to us and said, look, we want to invest in your company. And not only were they a geothermal company, Lucy, they also at that time had electric motor technology, which ultimately they sold to a company called Via Motors, which is all in the public filings of Razor and of Via. But so they had two good core asset groups in my mind. And so they came to them, we're really interested in your company and we want to finance these geothermal plants, because think of a geothermal plant like a power plant. That's what it is. It's a power plant that's powered by steam. And so ultimately what it really was is we're going to get inside your company. We're going to take your stock from about $8 or $9 a share, somewhere in there's my recollection, down to zero. Ultimately, they did do that and put the company in bankruptcy in Delaware, Lucy. So that company had to file for bankruptcy. In fact, in order to bring the case, the clients had to go to Delaware court and buy the cause of action to sue the brokers out of bankruptcy. Although we had to release Merrill, the parent company, but we didn't release any of their subsidiaries nor any of the other perpetrators. So at the end of the day, that was, as I said, a bigger version of what happened to Eagle Tech and Sedona and Internet Law Library, because what I've learned over time is what started out as a bulletin board fiefdom goes up the food chain all the way to the top, because there's bigger dollars to be made off of the overstocks and the tasers and the razors than there was off the Eagle Techs and the Sedonas and the Internet Law Libraries.
Now, I found fascinating the deal that Goldman did, again, written into your suit. So there was Goldman Sachs Execution and Clearing, Goldman, and Goldman Sachs International. So Goldman coordinated lending activities between 3 Goldman entities and laundered customer shares through Goldman International in order to allow them to come back into Goldman Sachs as broker shares rather than as customer shares. So now they could be lent to cover fails, and they could use it to hide fails by using shares that should never have been available to borrow. It's the first time I've ever seen that clever deal.
Well, yeah, exactly. As the complaint states, basically one of their founding members had a very large group of shares. They promised him that those shares would not be lent. Well, that's not exactly what happened. So the only way to disguise that is to send them overseas, get them washed, and then send them back. And then you can do whatever you want with them, which again is not uncommon. It's about obscurity. It's about hiding. It's about mischaracterizing. It's about lying. It's about all those things. No different than Merrill Lynch paying $400-something million for using all their customers' cash account shares several years ago. They ran their entire operation off of the cash account shares of their customers worldwide, according to the enforcement action. So,
and I think it happened in this case. They were using shares that were not supposed to be lent. They were cash.
Right.
So Razor is destroyed, files for bankruptcy. All of these companies that have a huge amount of fails. What happens then?
What happens is, and I'm not a tax lawyer, but what happens, I'm told by a prominent tax attorney friend of mine, is the ill-gotten gains don't even get taxed. I don't understand why. Ultimately, the shares that aren't delivered just go away, because when a bankruptcy court judge signs an order that says the bankruptcy plan is confirmed, that order says one of two things. It says, we're going to give the equity holders, because the shareholders are at the bottom of the creditor stack. You have secured creditors, various layers of secured creditors, various layers of unsecured creditors, and then you have the stockholders. They are the last person or entity to get paid. Those people either get pennies on the dollar and they don't get their stock, or they get nothing and don't get their stock. Wow, either one of those sound really exciting. So the reality is, as Rob Shapiro said very astutely, this kills jobs, this kills technologies, this kills families. And for that, somebody needs to pay a price.
Well, what did the SEC or the Justice Department, having all this evidence, say to any of these companies or the people that run the companies, you have to pay a price? What did they do?
The answer in Razor and every, other than the other cases we've talked about, is nothing happens. Nothing happens.
So now that you've been doing these cases for 20 years, what have you learned? What are the key takeaways about the companies, the system, the regulators?
Well, my key takeaways are, and I'm going to be very benevolent to all the regulators, because I have good friends there that do good work, but then I think the politics, sometimes the people at the top, aren't as good in my view. So here's my takeaway. The SEC and Wall Street is a revolving door. You're either going to the SEC from Wall Street, or you're going from the Wall Street to the SEC. It's a very cozy relationship. It is a place that is supported on a bipartisan basis. So this isn't a Republican or Democratic issue. It's both sides of the aisle that's allowed this to happen. Don't forget, as Suzanne Trimbass said very smartly, This was not a huge problem in 2000, okay? It only became a problem after they bought the NSCC, the stock lending company, okay? Although that gets into the obligation warehouse, which we'll talk about in a minute. So that's my first takeaway. My second takeaway is either the SEC is looking the other way, or they simply don't have the staff to handle this. I guess it depends on the case. I do believe there's a lot of people at the SEC that do work hard to try to stop this. But there seems to be a lot of others that frankly, I don't have a lot of respect for that aren't doing much. Either way, whether it's, underpaid and overworked, or whether they just don't want to mess with it, whichever it is that system that's allowing this to happen. The fines and the consequences are not commensurate with the crime. That's a takeaway. Number two, the fox is in the hen house. It's that simple. The DTC is a self-regulatory organization. The DTC, and actually the DTCC, that's the parent company, is owned principally by the prime brokers, the New York Stock Exchange, and others. They clear, almost $1 quadrillion of financial transactions per year. They are virtually untouchable, if you think about it, because they have immunity for their quasi-regulatory function. Now, they don't have immunity, just like the exchanges don't, for things outside their regulatory function. There's some recent cases in the Southern District of New York on this issue that are quite interesting, that are working their way through the court system. So in other words, you do things, stealing would not be something within the course and scope of your job as a regulator. So believe it or not, there are some lines, I think, being drawn. So the takeaway is don't let them regulate themselves. The next takeaway is there has to be transparency in this. If you let anything live in a dark room long enough, bad things are going to happen. That's just the human element in all of us, frankly. All of this must be exposed to the light, whether it's disclosure of shorts, just like you have to disclose in the 13D, whether it's not allowing these anonymous trading platforms, whether it's not allowing dark pools, whether it's not allowing this high-speed trading where you really are at a disadvantage if you're a normal investor. And there has to be total disclosure and transparency. Next, there has to be enforcement of the rules. For God's sakes, please tell me that you're not going to say that you can sell something that you don't deliver. It is a basic principle of legal concepts, of equitable concepts. It's a basic concept in anything. There is no place that I know of that you can sell something and not deliver it. You would call that cheating or theft. Okay? So ultimately, you have to force delivery. Next, you cannot be able to lend stock more than once. Why would you be able to do that? The result every single time is you're creating an artificial, counterfeit synthetic share, whatever you want to call it. And then ultimately, somebody needs to go to jail for all this, okay? Mm-hmm. They need to be putting people in jail. These consequences need to be severe. They need to be commensurate with the crime. Stop destroying people's lives and doing what a colleague of mine said, which is destroying truly the retirement funds of an entire generation is what this has wiped out. And it's continuing. So it must stop. It must stop.
So before we're going to go to questions from the community, but I realize I was remiss. Tell us the name of your law firm.
Well, actually, recently that's changed because two of my very fine partners have decided they don't want to take on these kind of causes anymore. Not anymore, but they want to go at a different pace and do more hourly work and less high risk work. So it used to be called Christian, Smith and Jewell. Now it is the Christian Levine Law Group. It is the same firm, except for those two very fine lawyers, Steve Smith and Gary Jewell, who incidentally worked their rear end off on all these cases and deserve credit for everything. I'm the mouthpiece here, but they deserve credit for a lot of work, especially Gary, that was done in these cases. But the new firm, which again is in the same building that we own and in the same people, is Christian Levine Law Group. Alan Levine's been here for 20 plus years, a very fine lawyer. And of course, we're teaming up, and I mentioned this before, with several other very large law firms. And I also want to mention my colleague, Alan Pollock. Alan Pollock's been with me for 10 years, ever since O'Quinn died. Alan Pollock is an incredible draftsman and does a lot of the pleadings that you see in Razor. In the recent case we filed, Harrington is his work. His firm is Warshaw and Bernstein in New York. And then we've teamed up recently. I can't tell you the name of the firms because they want to remain anonymous until we file the cases. But we've teamed up with two extremely large firms. So I've been successful in recruiting some very large firms to come join our team because they now see that this is true and they want to help stop it. And they've come aboard. And I'm talking about firms that are 20, 30 times as big as I am, or 50 times as big as I am. So
let's go to the questions now so we have as much time for them as possible. These are the questions that were sent in from the community. Are you aware of any veil piercing and or criminal precedent involved in naked short selling?
Okay, the answer is yes. And let's define what veil piercing is. What that means is that ultimately you can, if the ABC company is doing this to you, but ultimately the ABC company is owned by the XYZ company, you pierce right through the ABC company and get to the XYZ company. Why? Because XYZ company has all the money. So yes, we have been successful in doing that. So we're into semantics a little bit, frankly, verbiage. But when you plead a conspiracy and you say that these people are conspirators, you put all those people in one pot. You are able to treat them, if you're successful in your legal concepts, as one. That is, what one did and what the other did is almost immaterial. You're all liable for the whole thing, because whether you manufactured the gun knowing it was going to be used to murder somebody, or you drove the car down to Florida, or you pulled the pistol on the person and shot him in the head, you're all liable for murder. Well, this is financial murder we're talking about. So basically, if you're a co-conspirator, it ultimately culminates in veil piercing.
Next question. If proxy votes far outnumber the float, how would that be handled by regulatory agencies? And if it goes to court, will there be a squeeze or a settlement?
Well, there's many parts of that question. So let's start with the proxy vote. So as Suzanne Trimbath says in her book, Naked, Short, and Greedy, or whatever it's called.
Yes.
Basically, I've read the book. I forgot what it's called, Naked, Short, and Greedy. Thank you. Anyway, in her book, which is very good, incidentally, it talks about this issue. This issue of overvoting is what they call it. What the question that was posed is called overvoting at the DTC. She dealt with it when she worked at the DTC, if you can imagine, 25, 30 years ago, okay? So imagine that it's got worse. I will tell you, sadly, how it's dealt with. It just gets wiped out. I can't get into details, but I can tell you that the vote counters at proxy services will actually show that discrepancy the day before the record date. But on the record date, somehow it all just gets washed out. So it just acts like it, I see nothing, I know nothing, I do nothing, okay? And so ultimately, it's a joke, and it's a very sad joke, but that's how it's dealt with. It does impair corporate governance, though. In fact, there are other lawyers I know that are working on some of the theories for new cases about suing these perpetrators for destroying corporate governance. Think about whether a merger could have gone through or whatever. So that's that question. What was the second part of the question?
Well, if it goes to court, will there be a squeeze or a settlement?
Well, number one, if there is a squeeze, frankly, I think the listeners and viewers that we're talking to now have got the best game in town, because the best way to take on a bully is be a bigger bully, okay? And so ultimately, for these people that were viewing and listening to us right now, find companies that really make a difference, find companies that are really good to invest in, and go show them, that you're better at the game than they are. And obviously you've done that in GameStop. I don't know if you're going to be successful in AMC. And again, this is subject to talking to your lawyers that do that kind of thing. I'm not familiar with whether that can be done legally or not. It seems like it could. But nonetheless, going to court ultimately causes that overvoting situation to be resolved in part because in some cases, the perpetrators have had to buy stock from the company in order to satisfy the overhang or the difference.
And then the next question, in the case of overstock, could you explain the process for which their crypto dividend forced the short sellers to close? Did the SEC go to brokers and inform them that their clients were owed a dividend they couldn't provide and made them close the position?
Well, first, the chronology is a little off. When Patrick created the crypto dividend, this is my recollection, Patrick was the first, Overstock was the first company that the SEC actually approved a blockchain-based stock issuance, which was a preferred shares of stock. I had nothing to do with that transaction. I just happened to read the SEC filings because I was intrigued by it. But in our case, to my knowledge, that we handled, I don't think there was a crypto dividend. I think we simply just got the records that showed those imbalances, showed those fails to deliver, et cetera. So I don't know to what they're making reference to, frankly, because I don't recall any crypto aspect to that part of the case.
Well, I don't think they meant the cases that you did. I think it just must have been, well, they said the case of overstock. So no, I never saw that either.
Maybe there's a new case for overstock. I'm not handling that case, though, if that's the case.
Okay. Next question. Have either Lucy or Wes witnessed the SEC take strict action to market makers and brokers facilitating fraud? No way. Did you notice that, Wes?
Yes. You hesitated only for a millisecond. Well, look, let me tell you how I see this. And as a lawyer, I try to be more objective. I credit the SEC with the fines they've done, because let me tell you why, Lucy. This is important. At least it brought credibility so that myself and my colleagues could get out of our spacesuits and talk with authority to the court, for God's sake, okay? Because when you would talk to courts in the early 2000s, they would say, basically, get this guy over to the insane asylum, okay? Because you can't even imagine this, okay? And of course, it gets worse as these concepts get more sophisticated. So ultimately, it's way short of what needs to be done, but at least they're exposing what's going on. So go to FINRA, read the regulatory actions here, Canada, principally, some in London. Go to sec.gov, read the regulatory actions. At least, $400-something million that Merrill paid, that's, I don't know what they made off that, but that's not anything to sneeze at. So at least it exposed using customers' account shares. At least it exposed all the mismarking of tickets. At least it exposed the computers that are set up intentionally to mislead you. So let them keep doing that, because at least it's going to corroborate for us that are out there in the courthouse that it's true, that it's real.
From your experience, do you know any cases where a CUSIP number change caused naked shorts to cover? The CUSIP number is it's 9 characters that uniquely identifies a company or an issuer and the type of financial instrument. So did the number change cause naked shorts to cover?
Generally speaking, no. And let me tell you why. My dear friend, who I haven't talked to in a while, Gary Valinati, ran a company in Florida. They issued under a different QSIP number a share dividend. This has been 15 years ago, maybe. In doing so, it caused a run on the bank for a short period of time, a short squeeze. But ultimately, what did the brokers do? They just journal entered it, okay? Because we made it, the documents made it clear, which again, we didn't prepare the documents, transactional lawyers prepared those. Made it clear that in order to get a share dividend, you had to redeem your actual share. So we thought we got them, okay? But the problem is the brokers didn't enforce that, okay? They just legend over the shares. The DTC accepted the legend shares, and here we go. So what it required in that case, which the shareholders weren't willing to do, is each shareholder go to his broker and say, hey, I'm going to sue you if you don't turn my share in and get my share dividend. Then it would have worked. It would have worked, but it was missing that link. Why? Because again, this gets back to a rigged system, because you don't go to court when you do that, because under every agreement that you sign with your broker, you go to a FINRA arbitration. Now, I don't know if you've been to any of those lately, but it's not exactly friendly to customers who are buying stock. Okay.
So this goes into the next question. What rights do shareholders have? Who is ultimately responsible when those rights have been denied?
It's a great question. They have rights to file a class action, and it comes in many forms. Could they file a class action against the brokers? Yes. Could they file a class action against the company for not taking action against the brokers? Yes. If a company has actual knowledge of fraud that's being perpetrated against that company and takes no action, it is an absolute breach of fiduciary duty. So that's number one. Number two, so that's a cause of action against the company for doing nothing. That would be omission. Number two, you could sue the brokers as a class for the commission of doing it. Okay. The Harrington case we filed in the Southern District of New York is a large shareholder against the brokers. Okay. The very thing I'm speaking of. Or alternatively, I talked about it last time. If it depends on whether it's a direct or derivative cause of action. A derivative action means you put the corporation on notice. Listen, this has happened to us, to the company. You've taken no action. I'm telling you, I've been damaged by this. Other shareholders have been damaged. You need to bring an action against them, or we're going to bring that action. Most state laws will allow you to bring a derivative action depending upon the nature of the claim. And if the company doesn't bring it, you bring it in their name. So there is a vehicle by which shareholders can force the company, in some cases, it's a case-by-case analysis, to take action on your behalf and the other shareholders' behalf.
Now, this is the last question. Actually, there are two questions, but they belong together. Do you believe that this new wave of self-educated retail investors demanding reform in the market is the push we need to fix these major weaknesses in our economy? And the second question, how can APES bring change on the government level to ensure the stock markets and the governing bodies are fair and are for the people instead of for the 1%?
I tell you this, and I told friends ever since this GameStop thing happened, which don't forget, that company's in Grapevine, Texas, about 5 miles from where I grew up. So anyway, the point is, absolutely, this is critical. This group of apes, as they call themselves, need to be proud of what they're doing. They need to grow and grow and grow, and it needs to grow internationally also, because this is not just a U.S. problem. This is a worldwide problem. As I said last time, from trusted resources I know, this is a $250 trillion approximately problem and growing worldwide. What is it in the United States? I hear all kinds of numbers, but at least 100 trillion. Now that counts stocks, bonds, credit default swaps, derivatives, T-bills, for God's sake, that are being counterfeited. This all stems from electronically selling something you don't deliver. So what can you do? You can continue to grow. You can continue to speak out. You can continue to try to co-invest with each other in some legal way to where you can become a bigger bully than they are, for God's sake. Pick out the companies that you think are meritorious and go stand up for them. Okay, that's number one. So nobody has ever thought about doing that like you've done. So hoo-ah, as they say, to you men and women who are doing that. Number two, write your congressman, write your senators, send letters to the SEC, get on the internet, educate people, demand transparency, demand change. It is in its very base level, financial reform. It talks about me being, a legal advocate for financial reform. That's a nice way to say I'm sick of this crap and I'm going to stop it. Okay. So the bottom line is that you can be a big part of this. Frankly, what you're doing is mission critical to the cause. Keep it up. Do everything you can, every form of communication, every form of demand, every form that you can legally do it. Challenge the companies that aren't doing something to protect your interests. they owe you duties. They need to be doing something. So at the end of the day, you got to work against the companies that aren't doing anything. You got to work against the regulators who aren't doing anything and demand change. And until that gets to the point to where the people have rebelled long and hard enough, it's not going to change. Frankly, what we're doing is good. It exposes it. And what we're fixing to do, which is build it up and do a much bigger group of cases, that's coming, ladies and gentlemen. It's still not going to be big enough. It takes an enormous movement. Why? Because these people, are involved in the Fed. They're involved in the World Bank. They're involved in all of this. So this is what my friends refer to amorphously as the cabal. Okay, we're taking on the cabal. Who is that? Well, you'd have to kill me and shoot me because I really don't know. I know that there are I know who some of them are, I think, but I couldn't prove that in a court of law. I know it exists. It is a group of super elites and super wealthy people that control a lot of the world's economy. I don't know how big they are, who they are necessarily, but I know that they're involved in this, and we need to stop it. We need to demand fairness, honesty, integrity, and justice. This is the land of the free, the home of the brave, justice for all. Never forget that, okay? And I can assure you, this Texas gentleman will not ever forget it.
Thank you. That's a wrap. Thank you, Wes, for expertise, detailed look at how the system that is supposed to protect investors and companies works or doesn't work. And to Superstonk, which is making this information available to tens of thousands. Those are the numbers who watch the preceding videos. Thanks to Superstonk, because this is a time when the corporate media does not tell the story that you are seeing here.
So thank you both for coming and rejoining us today. That was a really hype way to close, Wes. I think you just got the apes really hyped. If you don't mind an encore question, one of our mods, Audibit, the author of House of Cards, he had one more question that he wanted us to pose to you. What happens when a company doesn't file bankruptcy but has a heavy short position like in Gamestop?
What happens in what respect?
So when a company doesn't file bankruptcy but has a heavy short position, so in all of the stories you were telling, everyone went bankrupt. What happens when that doesn't happen?
Well, when that doesn't happen, then you either need to demand the company take action, or ultimately you or tell them you're going to take action derivatively on their behalf, if you can put the package together and the lawyers together to do that. Or ultimately you file a class action yourself against all the people that you think are illegally shorting the stock. To do that, though, the sad part is it takes a lot of due diligence. That due diligence costs money. And while our firm does these cases mainly on a contingency, we do make the client at least pay for the due diligence with the experts and others in order to make sure that they have a case. But once they know they have a case, we will certainly look at it on a contingency basis. So the stumbling block there is to gather up enough shareholders to really form a group, a large enough group to make something happen. And secondly, to come up with the money in order to do the due diligence to do that. Frankly, the company should be doing that due diligence and should pay for it. They owe that duty to their shareholders. And I'm sorry to say that in GameStop's case, they haven't done anything. Why is that? I don't know. I haven't had a conversation with them. I've certainly tried to be candid, because I think they need to understand what's happened here, at least from my view. But that's the kind of action they can take.
Interesting. Well, we appreciate that. And again, Wes Christian, Lucy Komisar, we thank you for joining us. Apes of Superstonk, we appreciate you. And join us again for the next Superstonk Live AMA. Take care.
Honored to be here.